Hello everyone, and welcome to this Federalist Society virtual event. I'm Caroline Bryant, and I'm Associate Director of Practice Groups with the Federalist Society. Today, we're excited to host this webinar on the Trump classified documents case. Our speaker today is Steve Bradbury. Steve Bradbury served in the Trump administration as the Senate-confirmed General Counsel of the United States Department of Transportation. During his time at the Department of Transportation, he also served as the Acting Deputy Secretary of Transportation and briefly as the Acting Secretary of Transportation. During the Bush 43 administration, Mr. Bradbury served as the Principal Deputy and Acting Assistant Attorney General for the Office of Legal Counsel at the U.S. Department of Justice. Aside from government service, Mr. Bradbury has been a litigation partner at Kirkland & Ellis and at Deckert in Washington, D.C., where his practice focused on regulatory enforcement and investigations, rulemaking, and judicial review of agency actions, appellate cases, and antitrust matters. If you'd like to learn more about today's speaker, his full bio can be viewed on our website, fedsoc.org. After our speaker gives his presentation, we will turn to you, the audience, for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window. We will do our best to get to as many as we can. Finally, I'll note that, as always, all expression of opinion today are those of our guest speaker, not the Federalist Society. With that, Steve, thank you for joining us today, and the floor is yours.
Great. Caroline, thank you so much. Really appreciate the invitation from FedSoc to present this webinar. This relates to the momentous decision by District Judge Aileen Cannon in the Southern District of Florida to dismiss the documents case that Special Counsel Jack Smith brought against former President Trump and two other individuals. As you probably know, that's a case about classified materials that were allegedly retained by the former president after he left office, and also raises charges brought by grand jury proceeding against the former president for allegedly concealing documents and obstructing the investigation. But as you're probably also aware, there have been a lot of other issues raised in that criminal proceeding in Florida, and the case, it's fair to say, had gotten bogged down in a number of difficult, tricky preliminary issues, including issues relating to handling of classified evidence, allegations that the prosecutors had mishandled evidence, this is spoliation of evidence, etc. But then, critically, for purposes of the decision that we're going to discuss today, arguments were raised by the defendants in the case, former President Trump and the other two defendants, that Jack Smith, the special counsel, was improperly, actually unconstitutionally, appointed to his position by Attorney General Merrick Garland in violation of the Appointments Clause of the Constitution, and that should be a ground for dismissing the criminal case entirely. And then secondly, the former president and the other defendants raised another argument that involved the Appropriations Clause of the Constitution, arguing that Jack Smith, the special counsel, was paying for his prosecution through an appropriation from Congress that could not lawfully be used for this prosecution. And the district judge, Aileen Cannon, took up both of those issues, heard arguments from the special counsel's lawyer, Jay Bratt, from the lawyer representing Donald Trump and the other defendants, Emil Bove of the Blanche law firm that's representing the defendants in the case, and also from some heavy-hitting amici that introduced some amicus briefs, including former Attorney General Ed Meese and some big-name law professors with expertise on the issues of the Appointments Clause, the Appropriations Clause, etc. And heard argument on these two issues over 2 days in late June. And on July 15th, issued her big opinion. It's a 93-page opinion in which she concludes that the appointment of Jack Smith violates the Appointments Clause of the Constitution and that the only proper remedy is to dismiss the case, dismiss the charges in the Florida documents case entirely. She made it clear her ruling does not apply to the other Jack Smith case up in DC. That would have to be raised separately in that proceeding. But it does clear the slate in terms of the Florida documents case, at least for now. She also held that Jack Smith was improperly using appropriated money of the Justice Department, that the appropriation in question could not properly be used for this litigation for this special counsel. And he had actually spent more than $20 million in the prosecution so far. At least that was actually only through the end of 2023. So it's enormously expensive. And she said that was all improperly spent. But she concluded that she couldn't decide what the right remedy was for that appropriations clause violation, and that she didn't really need to impose a remedy because the appointments clause violation caused the whole case to go away. She suggested that the appropriate remedy for the appropriations clause problem was also dismissal, but she didn't have to reach that issue. But the bottom line from her ruling is that the case is, for now, dismissed. Jack Smith has filed a notice of appeal, and I'll talk at the end about what might happen following Judge Cannon's ruling. But let me talk a little bit about the basis for the ruling. So this is an appointments clause violation. And as you probably know, under the Constitution provides that the president, the default rule under the Constitution and the appointments clause is that the president nominates officers, and they are appointed with the advice and consent of the Senate, so that there's a nomination, Senate confirmation, and appointment. That's the default rule for officers of the United States. And the Supreme Court has said an officer of the United States is an officer occupying a continuing office established by law who exercises significant authority under the laws of the United States. There's a question whether an officer is a principal officer or an inferior officer, because the appointments clause goes on to say that with regard to other offices not mentioned in the Constitution, Congress may, by law, establish other offices and provide for the appointment of officers to those other offices in three different ways: by the president alone without Senate confirmation, by the heads of departments like the Attorney General, that's the head of the Justice Department, or by the courts of law. But the Supreme Court has made it clear that those types of offices where Congress may provide by law for the authority, for the appointment authority to involve, not to involve Senate confirmation, and to be exercised where Congress determines it proper by department heads, can only be what the Supreme Court has termed inferior offices. Actually, that's in the appointments clause, such other inferior offices as Congress may establish. And so the question, first of all, is whether Jack Smith is occupying an office, whether he is an office exercising significant authority under the laws of the United States, and has to be appointed in accordance with the appointments clause. And here it's very clear he is. In fact, he himself, in defending his appointment, characterized himself as an inferior officer. He is subject to some level, supervision by the Attorney General, but the Attorney General has made it clear that the appointment of Smith is subject to the existing Department of Justice regulations providing for special counsels, which creates some independence for those special counsels in the decision-making in the cases they bring. They have to keep the Attorney General apprised of major developments, but it's clear the Attorney General is not going to interfere with their decisions over the conduct of the case unless they do something that the Attorney General concludes is so inappropriate or unwarranted under established Justice Department policies that he's going to veto it. He's going to override it. And he has to explain why he's doing that. And then moreover, the special counsel cannot be removed from office by the attorney general under the regulations, except for cause, such as misconduct, violating department policies, or other good cause, etc. So it's pretty clear that this special counsel, Jack Smith, like other special counsels, like Rob Hur, like Robert Mueller, like Lawrence, previous special counsels that have been appointed historically, is exercising, and in fact, his appointment order expressly says he's exercising all of the authority of a U.S. attorney. He's just like a fully empowered U.S. attorney. And in fact, more so, he can file his charges in any district in the country, not just the district where he resides. And his exercise of this authority is subject to that insulation or independence under the special counsel regulations of the Department of Justice that I described. So it's very clear that at a minimum, Jack Smith is an inferior officer, not a mere employee subject to in total supervision, oversight, direction from higher ups within the Department of Justice. The court recognized that there's a substantial question here whether Jack Smith is not just an inferior officer, but in fact, a principal officer of the United States because of the extent of that authority, the power. I mean, if you just think about it, my gosh, he's prosecuting a former president of the United States. He's spending $20+ million every couple of years or whatever. He's taking dramatic actions. He's going up to the Supreme Court. And Attorney General Merrick Garland is saying, hey, I'm not interfering with what he's doing. I'm not second guessing any of these decisions. I'm not looking over his shoulder and directing him to do it one way or another. Boy, that sure sounds like principal officer authority. Judge Cannon made it clear she would incline to conclude that, in fact, Jack Smith is a principal officer in this position. But she concluded she didn't have to reach that question. Of course, if he were a principal officer of the United States, he could only be appointed by the president with Senate confirmation. And obviously, he wasn't appointed by the president. He was appointed by Merrick Garland, and there's no Senate confirmation involved in his appointment. So he would be unconstitutional, and everything he did would be invalid, unconstitutional, and that certainly would be a basis for dismissal. But the judge didn't go that route. Although she would incline to, she didn't feel she needed to, and she didn't feel she had all the facts about the exact nature of Merrick Garland's supervision of Jack Smith's office and decisions, etc. So she went the inferior officer route. But as I described earlier, under the Constitution, an inferior officer has to be appointed pursuant to a statute. Congress has to enact a statute that authorizes the Attorney General to appoint this inferior officer. And Judge Cannon had some analysis, some inquiry into, well, how clear does that statutory authorization have to be? Does Congress have to use precise language? Does it need to be abundantly clear that they're authorizing the creation of a new office and the appointment by the Attorney General to the officer who's going to fill that office in so many words? Again, she inclined toward that view that it does need to be clear, but she didn't rely on some clear statement rule of construction or analysis. She just went ahead and analyzed the particular statutory provisions that the Attorney General relied on in appointing Jack Smith to office, and that Jack Smith relied on in defending his own appointment in her court. And she went through those provisions in careful detail, statutory analysis. And it's fair to say, I think, that no prior court has ever analyzed these provisions on which the department historically has hung its hat for purposes of special counsel appointments as thoroughly as Judge Cannon does in her July 15th opinion. Justice Thomas, as you may know, in the recent United States versus Trump immunity decision from the court, filed a concurring opinion in that case in which he raised this issue and he questioned Jack Smith's appointment, whether it was consistent with the appointments clause. He didn't reach a conclusion, but he went through some of these same statutory provisions and raised real doubts about whether they suffice as a sufficient authorization from Congress for the Attorney General to appoint special counsel. But he did not go through that analysis as thoroughly as Judge Cannon does in this case. And there are two primary provisions of law that Jack Smith really emphasized in arguing for the constitutionality of his appointment. One is Section 515, 28 U.S.C. Section 515, which provides that the Attorney General may authorize U.S. attorneys, other attorneys specially appointed by law or specially provided for under law, to exercise authority of a U.S. attorney in any district of the country, whether or not they reside there. And then if the Attorney General is going to give that authority, this is authority sometimes referred to as special attorney authority, that those attorneys are to be commissioned, which really means they get a tasking from the Attorney General. What's the scope of what it is? What cases can they exercise this authority in? And then they are to be paid according to a schedule determined by the Attorney General. The second provision that Jack Smith relied on pretty heavily was Section 533 of 28 U.S.C. So 28 U.S.C. Section 533. This is a provision that actually sits within the FBI chapter, FBI section of Title 28 of the Department of Justice. So it's a little bit odd to think that it would be a provision that authorizes appointment of a special counsel who's not in the FBI. But this is a provision that authorizes the Attorney General to appoint officials to assist the FBI in its investigations and prosecutorial actions. So the FBI and FBI agents, as we all know, investigate criminal cases and participate with U.S. attorneys' offices in prosecuting those cases. They participate at trials and help out, et cetera. And this provision appears to indicate that the Attorney General can hire in special attorneys or can hire in people to help the FBI in these efforts. It doesn't specifically say it's limited to the FBI. It says the Attorney General may appoint officials. It uses the term officials. It doesn't say officers, to detect and prosecute crimes against the United States, to assist in other actions that the FBI may take. And so Jack Smith points to that provision and says, well, what happened here is the Attorney General appointed me, Jack Smith. I was a lawyer in private practice, and he appointed me into the department as an official to detect and prosecute crimes against the United States, in this case, crimes committed allegedly by former President Trump. And then under that previous provision, I referenced Section 515, he gave me all the authority of a U.S. attorney and allowed me to bring prosecutions in any district. The problem with all of this, Judge Cannon said, is it's just not adding up to an authorization in law from Congress for the Attorney General to appoint an officer to carry out the duties of this special counsel. She concluded that Section 515 is really just creating procedural requirements or liberties for a U.S. attorney or an otherwise appointed special attorney. Section 515 refers to, it says the Attorney General or any other officer of the department or any attorney specially appointed by the Attorney General under law may, when specifically directed by the Attorney General, conduct any kind of legal proceeding, including grand jury proceedings, etc., in any a district, whether or not he's a resident of that district. And that term, attorney specially appointed by the Attorney General under law, obviously depends on some other law that creates the authority to appoint. And logically, for purposes of that provision, the other law is a different section of Title 28. It's Title 28, Section 543, which allows the Attorney General to appoint special attorneys to assist U.S. attorneys. And moreover, it provides that the Attorney General may remove those special attorneys. So basically, at-will removal of those attorneys. Jack Smith disavowed any reliance on that Section 543 because he's not an assistant to some U.S. attorney. He is himself hanging out there like a full-blown U.S. attorney. In fact, a mega U.S. attorney or super U.S. attorney, because he can go anywhere in the country and prosecute Donald Trump, allegedly anywhere. And so he didn't want to say I'm an assistant to a U.S. attorney. But it's pretty compelling, the analysis, I think, that Judge Cannon comes to, that 515 doesn't create the authority. Then she goes through at length 533, which is the one, again, in the FBI section of Title 28, and concludes that an official, for purposes of the appointment in 533, is best read to mean an employee or mid-level official, and not a constitutional officer exercising significant authority under the laws of the United States. She wouldn't accept that it could include all of the above. It could include any officer as well as employee. And I have to say, I think, she makes a very good analysis on that. I think it's pretty strong. So putting this together, she concludes, sorry, Jack Smith, the Attorney General actually did not have statutory authority to appoint you as special counsel. Now, one issue here, clear issue, which was pressed very hard by Jack Smith, and will obviously be pressed very hard on appeal, is that, well, wait a minute, there's a long history here. Past attorneys general have appointed lawyers and former judges, et cetera, from outside the department to function as special prosecutors or special counsel. They did that way back before the independent counsel law was enacted. You'll recall Watergate. Watergate was prosecuted by Archibald Cox as special prosecutor, and then later Leon Jaworski after Cox was fired by President Nixon. And that was done pursuant to these same provisions and regulations that the department had in place for special prosecutors. And way back at that time, in a decision the Supreme Court issued, 1974, United States versus Nixon, the Supreme Court recognized that appointment and basically said in a preliminary discussion in the opinion that the appointment of Jaworski was made by the Attorney General properly under these same provisions of law. Didn't actually reference Section 533, but said that the Attorney General was vested by Congress under various of these provisions, including Section 515, which I referenced, to appoint the special prosecutor, and also recognized that under Justice Department regulations at the time, the special prosecutor was given independence and could make decisions. In that case, what was at issue was the special prosecutor, Leon Jaworski, had subpoenaed the president of the White House for the White House tapes, and the president was trying to assert executive privilege over it and claimed that the special prosecutor couldn't get the tapes. special prosecutor took this up to the Supreme Court, and President Nixon at the time argued that the Supreme Court couldn't hear the case, that it was a political question because it was an intra-branch dispute within the executive branch. And it's ultimately the determination of the president as to whether to assert executive privilege, and that couldn't be questioned by the courts. And the Supreme Court rejected these arguments, and in the course of rejecting the arguments, they recognized that Leon Jaworski had been appointed as special prosecutor, and under the DOJ regs, he had this independence. And those regulations, as long as they remained in effect, were binding on the department and on President Nixon. And therefore, because of this independence, there was a true concrete dispute that could be heard by the court. And critically, and Judge Cannon goes through this in great detail. What she did was she got all the briefs from the United States versus Nixon case. She read everything. She looked at all the questions presented, and she found that, in that case, President Nixon had disavowed any argument that the special prosecutor, Leon Jaworski, was improperly appointed. And actually, President Nixon disavowed any argument challenging his independence under those Justice Department regulations. And in fact, it was really that concession that torpedoed his case. Caused him to lose that case, because the Supreme Court said, well, he's independent under those regulations and they're binding. So Judge Cannon concludes that the statements in the United States versus Nixon case to the effect that Jaworski was properly appointed, that Congress had vested the Attorney General with the authority to appoint special counsel under Section 515 and some related general provisions about the Attorney General's authority, that was just dicta in the Supreme Court's case, that it wasn't essential to the holding, because essentially it had been assumed, and President Nixon didn't challenge these assumptions. Well, it's always a little bit perilous for a district court to treat statements, clear statements in Supreme Court opinions, as dicta or not controlling precedent. She's got a pretty good analysis, and she, as I say, she really thoroughly looked at the case and all the arguments raised. She has a good analysis as to why these questions were assumed in the Nixon case and not really decided, and that therefore it's not binding on her. However, previous courts up here in DC, in the DC Circuit, have relied on the Nixon statement to conclude that previous special counsels were properly appointed pursuant to authority enacted by law by Congress under these very provisions of Title 28. And a district judge, Judge Dabney Friedrich, went through that with regard to special counsel Mueller, and concluded that, and the DC Circuit in two previous decisions, one involving Judge Lawrence Walsh, who was appointed initially as special prosecutor and then as an independent counsel, concluded that he was properly appointed. And then later, a DC Circuit decision enforced a subpoena brought by special counsel Mueller, and the party subpoenaed challenged the appointment of Mueller. And the DC Circuit, in a unanimous three-judge opinion authored by Judge Rogers, concluded that Mueller was properly appointed in accordance with the Appointments Clause, because these provisions of law give the Attorney General that authority to appoint a special counsel. And so previous cases in the DC Circuit have relied on this language from United States versus Nixon to affirm the appointment of special counsels under the Appointments Clause. Judge Cannon's opinion is diametrically in conflict with those DC Circuit decisions. And then there was a later DC District Court decision that followed, that relied on the previous DC Circuit decisions in United States versus Nixon. And so you definitely have a conflict between Judge Cannon's decision and the DC Circuit. And I'll talk in a second about what that might mean on appeal. Just very briefly, on the issue of the appropriations clause, the appropriation that Jack Smith is using to spend, again, tens of millions of dollars on this investigation and prosecution of former President Trump is a permanent, indefinite appropriation that Congress had enacted to fund the work of the independent counsel. And you'll recall from the 1970s, the Ethics in Government Act of 1978, until it was repealed in 1999, and with a couple of years of it not being reauthorized in the middle of that period, there was the independent counsel law. And that was a clear express authority to appoint an independent counsel. It was authority given to a special panel of judges. And that's the appointment authority that was upheld in Morrison versus Olson. Now, you can question the ongoing validity of Morrison versus Olson, but it's clearly binding on lower courts. But Congress allowed the independent counsel law to expire in 1999. And it was then that Attorney General Reno came up with the current regulations that govern the conduct of the appointment of special counsels, the conduct of their investigations, their independence, and that we're currently operating under for purposes of Jack Smith's investigation. But Congress had separately appropriated money for the functioning of those independent counsels, and in authorizing that appropriation, Congress also recognized that special counsels might have been appointed otherwise by other law, not just the independent counsel law. And so that appropriation remains on the books. And what it says is there's a permanent, indefinite appropriation for the expenses of a prosecutor appointed under the independent counsel statute, an independent counsel appointed under the independent counsel law, which is now expired, or other law. And Judge Cannon concluded that, well, there is no other law, as she just analyzed for appointments clause purposes. And so therefore, there's no other law that could justify the expenditure of funds under this appropriation by Jack Smith. And therefore, all the money he spent was improperly spent. And again, it's more than $20 million. At this point, it's probably $30 million. I don't know. He's got a big staff. He's doing all kinds of stuff. He's running these two big prosecutions, et cetera. But Jack Smith said, well, that's not the end of the story, because the Department of Justice has set aside $1 billion of its appropriated funds for purposes of this special counsel investigation, and they can use those other funds at any time. I could be authorized. I could seek authorization and get authorization to use those other funds. So it shouldn't be a problem if this appropriation is not the lawful appropriation. Now, as I say, Judge Cannon was very skeptical of that, but she concluded she didn't have to reach the question of remedy. So it was the appointments clause that did the trick. She dismissed the case entirely. I think she was right to conclude that there wasn't any other remedy to the appointments clause violation that she could put in place. This was not some mere technical violation. She concluded there really is no office here, and you can't have an officer without an office. And so nothing Jack Smith has done has been appropriate. It can't be ratified after the fact. And President Trump had raised the issue in a timely fashion. So she said it's all teed up, and therefore the proper remedy is to sweep it all away and dismiss the case. As I mentioned, Jack Smith has appealed or has filed a notice of appeal. That would be to the 11th Circuit. The 11th Circuit has not, as far as I know, ruled on the question of the validity of appointment of a special counsel. in fact, I know they haven't because Judge Cannon said there wasn't controlling. This is a question of first impression in her circuit. So he'll probably seek appeal and perhaps try to expedite that appeal in the 11th Circuit. You might wonder, well, would he perhaps seek to leapfrog the 11th Circuit and go straight to the Supreme Court and file a cert petition to try to get this teed up and decided definitively as quickly as possible by the Supreme Court, so that he could continue to pursue his prosecution to the extent there's any air left in it and he has any hope at all of moving forward before Election Day, which certainly seems impossible at this point. On the other hand, there's reason to question whether that would be a good strategy, because one thing is for sure, in the Supreme Court, if the case were accepted and teed up for merits argument and addressing straight up by the Supreme Court, they are not going to be satisfied simply relying on the quick statements, preliminary statements that were made by the court in 1974 in the United States versus Nixon. They're going to reach the question anew, and they're going to go through the full-blown analysis like Judge Cannon did. And I'm not sure Jack Smith really wants to take that on, given how he fared through that analysis here in this court. I think perhaps more likely he'll seek a quick appeal in the 11th Circuit and try to argue to the 11th Circuit that, like the DC Circuit, they must accept the language in United States versus Nixon, not question it, not try to upset all these past precedents, and send it back to the district court to continue the prosecution. They might even ask for the 11th Circuit to send it back to a different judge in the district court based on an argument that Judge Cannon has made up her mind about some of these issues. But so that's my summary of the case. It's clear it's very, very significant. I mean, if you think about it, what it means is Robert Hur was unconstitutional, Bob Mueller was unconstitutional, many previous special counsels were at least likely unconstitutional under the same analysis. So it's a big deal. It really would affect the ability of a future president to rely on the sort of imputed or reputed independence of a special counsel to get around a dicey conflict of interest type prosecution. Many White Houses, many presidents face these issues and sometimes find it politically expedient for the Justice Department to appoint a special counsel so they can say, look, it's all being handled independently, et cetera. This would really constrain the ability of presidents to do that. They'd actually have to give those prosecutions, those investigations to Senate-confirmed U.S. attorneys who would be ultimately subject to removal by the president, and therefore they could not claim that political insulation. It might cause Congress to go back to the drawing board and enact some kind of express authorization for a special counsel. But I think that's politically fraught, and Congress is going to hold its fire until perhaps the Supreme Court weighs in on this ultimately. So thank you very much, Caroline, and I welcome any questions.
Great, Steve, thank you so much. That was an incredibly informative, thorough presentation. So first question, and forgive me if you answer this, but I don't think you did. So you mentioned Judge Cannon doesn't have to sort the 20 to 30 million spent by Jack Smith. Would this be an area where Congress could step in to get the enormous amount of appropriations money back, or kind of where will this go next?
Well, that money is spent and it's like water under the bridge. I don't know where Congress would get it back from. Jack Smith isn't holding $20 million that he could return. It's spent money. And it's possible that the Attorney General could, if necessary, try to move money from other accounts controlled by the Department of Justice to cover future expenses. of the special counsel. But in terms of past expenses, that money is out the door, and it's gone to however many different contractors or employees, and I don't foresee any serious effort or even possibility of getting that money back.
Great. And then second question, so do principal officers need to be the highest authority in the agency, like the Attorney General, or can U.S. attorneys be considered principal officers?
Well, that's a great question. From the beginning of the country, U.S. attorneys were considered principal officers. They were all, and of course, they are appointed by the president with Senate confirmation. Originally under the Judiciary Act of 1789, you had an attorney general. He was really a part-time lawyer for the department who argued cases in the Supreme Court and rendered opinions on questions of law. And then you had all the separate U.S. attorneys, or they were district attorneys at the time, to actually litigate for the United States and prosecute crimes and cases, etc. They were principal attorneys, principal officers. Now, however, since 1870, you've got a Department of Justice structure. And it's clear that the Attorney General is the department head and is required to direct the functions of the U.S. attorneys in carrying out their litigation duties and their prosecutions, etc. So it does appear that U.S. attorneys, even though appointed by the president and subject to removal by the president at will, do report to the Attorney General and are subject to the supervision of the Attorney General. Now, as Judge Cannon goes through in her opinion pretty extensively, it's not a clear question where the line is between a principal officer and an inferior officer. You have two kind of paradigmatic cases that analyze the question. You got Morrison versus Olson, which looked at the fact that the independent counsel was supervised, at least to some extent, by the Attorney General, and could be removed at least for cause by the Attorney General, and was not making any policy for the Department of Justice, and was also limited to a particular case or cases that were she was tasked with prosecuting. And on those grounds, the Supreme Court there said she's an inferior officer. But then you got a more recent case from 1997, Edmond versus United States, which has to do with Coast Guard judges who hear criminal appeals for the Coast Guard. And there, the Supreme Court applied a different analysis as to conclude that those judges were inferior officers. And they really look at the structure, the line of supervision. And they said, okay, this officer, this judge, Coast Guard judge, is subject to supervision and direction and reports to another executive official. Really, I think at that time, the Secretary of Transportation, and not directly to the president, and is removable at will. And within that structure, that was enough for the court to conclude that those judges were inferior officers. But Judge Cannon goes through and says, this is not a clear question. And again, as I mentioned before, for purposes of this case, she concluded it was really a factual issue. There were factual issues as to how much supervisory authority Attorney General Garland was exercising over Jack Smith. Therefore, she said it was just a difficult question. And she was a little frustrated because she had asked about holding an evidentiary hearing on these questions, and the parties didn't want that. They wanted her to decide it as a question of law, and particularly Jack Smith. He said, you can't get into those questions because that gets into matters of deliberative process privilege within the department. My communications with the Attorney General, his supervision of me, you can't get into any of that. And so he waved her off. And she was a little frustrated by that, but what she basically said was, okay, I'm just going to assume he's an inferior officer and go on those grounds. And on that basis, she concluded he was not properly appointed.
Great. So we have two more questions about the enormous amount of money spent
Yeah.
So people wonder, could either the False Claims Act or liability under the Anti-Deficiency Act be used to recover that appropriations, or as again, as you just said, the money spent, there's no way to get it back?
Well, as I think people know, under the Constitution, it's prohibited to make an expenditure of funds except pursuant to an appropriation enacted by Congress. And the Anti-Deficiency Act is a statute, pretty old statute from the 19th century, that goes further and says, goes beyond the Constitution and says not only is it prohibited to expend funds unless you have an appropriation passed by Congress, but you also cannot incur an obligation, that is, incur a debt to expend funds in the future for some action. And basically, you can't sign an IOU on behalf of the United States unless you've got an appropriation passed by Congress. And this is criminal. So it actually is a crime to violate the Anti-Deficiency Act, to incur an obligation on behalf of the United States where you lack a lawful appropriation. But nobody has ever been prosecuted for that crime. Yeah, potentially there could be questions there if money was spent without a proper appropriation. Now, I think Jack Smith would have a defense that the Attorney General and the Department of Justice told him this was the right appropriation to use, and it was lawful for him to use it. So in terms of his personal liability and his staff, they probably have a very strong defense, since they were told they could spend this money. In terms of False Claims Act, that generally speaking involves somebody out in the real world who's harmed by somebody making a representation that they have authority to do something, for example, on behalf of the United States, when they don't really have the authority. And I don't know, other than President Trump and his co-defendants, I'm not sure who could be plaintiffs in such a claim under the False Claims Act. But I haven't given that really any thoughts. And it's an interesting question. It certainly is galling to think about this massive amount of money being spent. That's true of those independent counsels in the past. Oh my Lord, Judge Walsh, who who investigated and prosecuted Iran-Contra as an independent counsel, the amount of money he spent, the size of his staff, incredible. It was like a whole department of government unto itself. So these guys, when they get these special appointments, they pull out all the stops. They don't see any economies. There's no political benefit to them from applying economies to their prosecution, to their investigation. They have every incentive to pull out all the stops. And certainly Jack Smith, I will say, has that reputation. He's the guy who went after Governor McDonnell in Virginia and got slapped down by the Supreme Court for overreading the bribery statute. And he got slapped down by the Supreme Court in Trump versus United States here, and now again by Judge Cannon. So he's pretty aggressive in the arguments he makes. Certainly the charges he brought in the indictment in DC, the January 6th indictment, really a strain. I mean, he's really reaching. So he's very aggressive, and huge expenditures go along with that. And it's really galling, should be for any citizen who cares about wasteful government spending.
Well, I think lots of our viewers are concerned about it based off of the questions. So you mentioned, I believe, the Reno regulations, and I think someone wants to know, are the Reno regulations in any way incomplete for the purposes of appointing a special counsel?
Well, again, the appointments clause, this is the whole thrust of Judge Cannon's opinion. The appointments clause requires the appointment authority to be in statute. In other words, Congress must pass a statute, a law, that authorizes the Attorney General to make the appointment. So the Attorney General cannot create himself authority to appoint inferior officers by regulation. He has to find that elsewhere. And those regulations that Attorney General Reno promulgated in 1999 purported to rely on some of these other statutory provisions that I've mentioned, although not Section 533, the FBI provision, but a number of the other ones that I've gone through and mentioned. So she recognized, and I think she was advised by Office of Legal Counsel, which I used to head up. She recognized that she had to find authority in law to be able to do these appointments. And then she issued these regulations, which are still on the books. And in fact, in this case, the Judge Cannon decided no party challenged the validity of the regulations, the special counsel regulations. And again, what the special counsel regulations do is set forth the circumstances in which the Attorney General will appoint a special counsel, and then the authorities of the special counsel, the limitations on the supervision of the special counsel, the removal, the reporting requirements, etc. It's 10 sections in these regulations that go through in some detail, and they were really written in 1999 to try to give Congress and the public some comfort about, yeah, we still are going to appoint special counsels when there's a conflict of interest, between the president or the Justice Department on some case, and it's appropriate for the public interest to have a special counsel come in from outside the department to handle it specially. And we're going to insulate those special counsels with all of these limitations to tell the public, don't worry, we're going to have this good solution for reliable, independent investigation you can have confidence in. Again, it's a kind of a political or PR thing, and they did take it up. I mean, some of you might have seen an op-ed in the New York Times recently in response to Judge Cannon's opinion by Neil Katyal, the former acting Solicitor General. He apparently was on Janet Reno's staff and helped in drafting these regulations, and made it clear in his op-ed that, at the time, which I'm sure they did, they took it up to the Hill. And they took these ideas around to the judiciary staff, judiciary committee members, and other members on the Hill to kind of shop it around and let them know, here's what we plan to do in these rules, and insulate the special counsels. And this is our solution. And what he indicates is, not surprisingly, a lot of members of Congress liked the idea, sounded good to them. They supported it. Maybe they had him add some of the reporting requirements. There's reporting requirements the Attorney General has to make to the committees in Congress if he does certain things to squash the prosecution of a special counsel or remove the special counsel for cause. So the suggestion is, Congress has essentially ratified this whole structure. They're comfortable with it. They've acquiesced, or they really like it. Everybody's happy with it. So Judge Cannon, you shouldn't venture into this deep water. You're just a district judge, and you should just basically shut up and sit back and say, oh, the Supreme Court already said it was okay, and everybody's been doing it for years, and other courts have said it's okay, so I guess I'll say it's okay too. That's what they wanted her to do, and she didn't do that. So we'll see what happens in the 11th Circuit and potentially in the Supreme Court. But again, those regulations are still on the books for what they're worth. But again, they don't create the appointment authority. That has to come from a law. And so if it doesn't exist, those regulations are nice and people might like them, but there's no such thing as a special counsel who could be appointed from outside the department. And those regulations would, in effect, have no effect.
So I believe the last question that we're going to have time for, could you comment how political officers benefit from appointing independent special counsels? And do view any issues that might arise from that in your mind?
Well, we saw it recently with David Weiss and the investigation and prosecution of Hunter Biden, the president's son. This structure allows the attorney general to sit back and sort of put his hands up and say, hey, it's not me. You know, I gave the authority to this guy over here, this U.S. attorney. Now, at first, he tried to say he had given the authority to David Weiss as U.S. attorney, but in fact did not give the Section 515 authority to prosecute in other districts. So in fact, for a long time, U.S. Attorney Weiss was inhibited from filing cases prosecuting Hunter Biden in California or DC because he had to get the permission and cooperation of the U.S. attorneys in those districts and couldn't get that. But the attorney general was saying, oh, I gave him all the authority he needs. But when push came to shove, and it was clear that he had tried and failed to get the approval to do that in other districts, then the attorney general was kind of forced as a political matter to actually give him all the authority of a special counsel under Section 515. Now, he is a validly appointed U.S. attorney, David Weiss. So it's a different thing, but it illustrates the point that when you've got a scandal brewing in the executive branch, Congress is on the hunt, the press is snooping around, you've got some allegation that's colorable, that there's probable cause to think a crime was committed that involves the president's family, or some other senior member of the president's administration, et cetera, the attorney general is in a hard place. All the political pressures on the attorney general, of course, also on the president. Who's going to make the decisions as to whether to bring this prosecution? Who's going to try to sweep it under the rug? Who's going to make the hard decisions? Are you going to go or no go on the case? And so the attorney general, historically, it's been true, finds it politically beneficial to alleviate that pressure by saying, oh, I'm going to appoint a special counsel. And I'm going to bring some reputable former judge or former prosecutor in from the private sector. I'm going to give him all the authority he needs. I'm not going to touch it. I'm not going to interfere. And there he goes. So don't look at me. You know, I'm not interfering. I'm not running this. It's that special counsel. So it is politically very tempting to do that. It can, you know, frustrate the heck out of the president and a White House when they have to deal with the special counsel, who again often goes off the rails, often goes crazy with a deeper and deeper and deeper investigation and document requests and all kinds of subpoenas and all kinds of stuff, because again, they have no limit on their budgets, typically, historically, under the way it's been done. All of that will end. All of that is gone if Judge Cannon's opinion holds and is ultimately upheld by the Supreme Court. If the 11th Circuit agrees with her and affirms her decision, no doubt about it, that's going to go to the Supreme Court, because you've got a clear split between the 11th Circuit and the DC Circuit at that point. And you know how important the DC Circuit is because the Justice Department is here in the DC Circuit. So, and of course, the Justice Department likes the DC Circuit approach. So it would definitely get to the Supreme Court, and you would have another huge, monumental Supreme Court opinion next term. And I think if the Supreme Court ultimately agrees with Judge Cannon and strikes down the special counsels as we know them, there'll be a lot of pressure on Congress to go back to the drawing board and enact a new statute explicitly authorizing the Attorney General to appoint special counsels with certain independent attributes for purposes of carrying out investigations where there's a conflict of interest with the president or his administration. So that would likely be down the road, be a big political discussion. You know, are we creating a new independent counsel law with all of the downsides of that, et cetera? But you're definitely going to have a new, you know, the Supreme Court today is taking the appointments clause very seriously, far more seriously than the Supreme Court took it in 1974 when it decided United States versus Nixon. And today's Supreme Court, and even Morrison versus Olson, I think they're going to take a different approach to analyzing these questions. And the Supreme Court today's Supreme Court is going to make sure that the Congress and the executive branch have to stick to the requirements of the Appointments Clause.
Well, I feel like that's a great note to end on. On behalf of the Federalist Society, I want to thank Steve for the benefit of his time and expertise today. Thank you also to the audience members who joined us. We greatly appreciate your participation. Check out our website, fedsoc.org, or follow us on all major social media platforms. Thank you once more for tuning in, and with that, we are adjourned.